Salute to everybody. Make sure y'all slapping that like button. Let me zoom it a little bit better for y'all so y'all can see it better. Let's just kind of scroll through this thing and just see what's going on. The action arises out of the defendant Marcellus Wiley's intentional sexual assault rape of the plaintiff defendant's trustees of the Columbia University in the city of New York and Columbia's University. Collectively, the Columbia defendants' negligent and reckless failure to protect its students and plaintiff in particular against sexual predators and defendant Marcellus Wiley in particular. And the Columbia defendants' unconscionable and negligent response to the handling of the sexual assault by Marcellus Wiley against the plaintiffs. Because look, if people was making claims, you can say all of this and say all of that, Marcellus. But if they was making claims, one person said they went to the police. I think it was the Northern California, Northern Cali campus student from college. One person went to the police. If people are making their police reports and all these different things are happening, then there's a paper trail here. So regardless if you're saying people, you coming back over people's house and all of this, I don't know what's going on. But if people were contacted the school, they said they made the school aware, okay, administrative people at the school, they failed to protect them. Once they said they was going to suspend you, allegedly. And then another time they said, you know what, we really can't do nothing right now because he got an upcoming game. So what type of vibes is that? That is nasty work, bro. That's nasty. Okay, nature of the claim. The action is timely pursuant to New York's Adult Survivors Act. That's when people can still come out after a certain amount of years. You can come out still and name your accusers, okay? The plaintiff was over 18 years of age at the time of the assault and other incidents set forth herein. Now, the defendants are liable for intentional and negligent acts and omissions, which means leaving out something, right? Omission is like a lie too as well. If I tell you part of a story and I'm not telling you everything, that means I omitted it. That means I left that part out. And that's what an omission is, right? So omissions which resulted in plaintiffs being a victim of sexual assault and resulted in serious psychological, physical, and emotional harm suffered by the plaintiff. Now, the defendants trustees of Columbia University in the city of New York, Columbia Corporation, is a domestic not-for-profit corporation organized under the laws of the state of New York, and its principal place of business in the state of New York, County of New York, is located on Low Memorial Library, 535 West 116th Street, New York. They give you the zip code as well. Columbia Corporation is the governing body of Columbia University, and the corporation is comprised of a collection of well-established, politically connected business people from within and outside of the city of New York. Upon information and belief, Columbia Corporation oversees, operates, manages, and or controls all faculty and senior administrative appointments, monitors the budget, supervises the endowment, sets policies, and protects Columbia University property. Now, the defendant, Columbia University, is domestic. Okay, they said that already. I'm reading that again. Okay, skip. All right, cool. Responded for caring for the plaintiff after the sexual assault. Wait. Okay, A, recognizing the response. Okay, wait. A, recognizing and responding to the serial sexual predator, Marcellus Wiley. B, responding to and caring for plaintiff after the sexual assault by the defendant. See, he's talking about that right there, saying, look, we was in your room. We was in your bedroom. You know what I mean? We still was in the room. Woo, woo, woo. We started still woo, woo, woo. But in the actual filing, they saying you responded to and caring for the plaintiff after the actual assault by the defendant Marcus Wiley. And at all time relevant herein, the defendants are vicariously liable for the acts of each other. All times relevant herein, defendant Marcellus Wiley was a resident of New York County, state of New York, residing in Columbia University dormitory. So he was at the dorms. The plaintiff is a resident of Pennsylvania. Okay, plaintiff is Pennsylvania. The assault. Let's go on. And the callous and university's callous and abusive response. Okay. In the fall of 1994, the defendant Marcellus Wiley was a Columbia University sophomore and star running back. He said he was a freshman or sophomore. I think he said he was a freshman though. I think he said they got this wrong, right? Okay. Was a sophomore and star running back. He said he wasn't a star. He spoke to these 2 points. Okay. And a star running back, but who's to say he wasn't? On Columbia University's football team. The plaintiff and the defendant Marcellus Wiley became friendly acquaintances at the start of the plaintiff's freshman year at Columbia. So look, here we go. So you said you was a freshman at the time, but they said that they knew you since you was a freshman. That's when y'all got acquainted. Okay, connections being connected. Year at Columbia University, traveling in the same social circles, unbeknownst to the plaintiff at the time that Columbia University had received multiple complaints from a female Columbia University students beginning in the fall of 1993, all of which alleged that the defendant Marcellus Wiley had actually assaulted and or raped them. Okay. On November 18, 1994, the plaintiff and defendant Marcellus Wiley met in the dorm room of a friend of the plaintiff's, of hers, to listen to some music, allegedly. Defendant Marcellus Wiley told the plaintiff that he would come to visit her later that evening in her room. The plaintiff responded, okay, but I don't want to have sex. I am a Virgin Mary, sir. Defendant Marcellus Wiley laughed and responded, relax, relax. Wow, I don't mean like that. I'm just going to come by there to get food from grandma's restaurant. So I'll just come up to say hi before I head back. Defendant then joked that nobody liked having sex with virgins. Only the Holy Ghost, I guessed. Okay, cool. Plaintiff, feeling embarrassed, apologized and assured defendant that she was just being straight up so that he would not feel misled. So defendant Marcellus Wiley then stated, ain't nobody trying to have sex with no virgin. Don't worry, I got you. Just coming to hang out a while and while I eat, and I don't even have condoms on me. Sure, boy. That sounds kind of editorial. I don't know, homie. You ain't got no condom. What the hell that had to do? But that never stopped nothing. People got babies everywhere talking about they supposed to wrap it up. Anyway, a short time later, the defendant Marcellus Wiley arrived at the plaintiff's single dormitory room on the 9th floor of the Shapiro Hall with his dinner. After a few minutes, defendant pulled plaintiff to him without warning and began kissing her forcefully. The defendant towered over the plaintiff at 6'4" and approximately 250 pounds. The defendant forcefully removed the plaintiff's clothes without the plaintiff's permission. The plaintiff never been naked in front of another person before, and the 250 pound defendant Marcellus Wiley then lifted the plaintiff, forced her face down onto the mattress and climbed on top of her, pinned her face down on the bed by the defendant's forearm on her back of her neck, and the plaintiff could barely breathe and feared for her life. Now, the defendant Marcellus Wiley then actually assaulted the plaintiff, raping her multiple times in the Columbia University dorm room. At one point, after the first time the defendant Marcellus Wiley actually assaulted the plaintiff managed to get out from under the defendant and move towards the door, hoping to escape the room. Unable to find her clothes on the floor of the dark room, the plaintiff could hear voices in the hall and was considering fleeing the room naked when the defendant stated, "Come back here. Don't make me come over there and get you." Overcome by terror, the plaintiff froze. The defendant then pulled the plaintiff back onto the bed and actually assaulted her again. The plaintiff did not consent to the actual contact with defendant Marcellus Wiley. The plaintiff was over the age of 18 at the time the defendant Marcellus Wiley actually assaulted her. The actual assault on the plaintiff is an actual offense as described in New York Penal Law 103.35 and other applicable Penal Law Article 130 actual offenses. Now, a few days later in November 23rd, 1994, the plaintiff invited a friend to her mother's house in Brockton, Massachusetts for Thanksgiving holiday. On a return trip, the plaintiff broke down in tears and confided in her friend that defendant Marcellus Wiley had raped her. The plaintiff's friends persuaded the plaintiff to seek help at Columbia's University Rape Crisis Center. Now, when the plaintiff arrived back in New York City, she went directly to see Rachel Efron, a clinical psychologist at Columbia University's Department of Health Services and the director of the Columbia University Rape Crisis Center. With Efron's encouragement, the plaintiff reported the rape to a series of administrators, all of whom were dismissive of the rape. Now, the dean of freshmen took the plaintiff's written statement and then sent the plaintiff to then residential Dean Kathleen McDermott. Okay, look now. So you ain't even this big millionaire yet. You said you're not a star player, right? So nobody even know if you're going to make it to the league, bro. But yet this person is going to the Great Crisis Center and already documenting written statements against you about what happened. Okay. This is not looking good for you, Marcellus, regardless if we think it happened 31 years later, 21 years later, don't matter, bro. Craig David, 7 days, Craig David's, whatever, homie. This don't look good because this happened way before then. And they did actually seek help in this situation. It's all alleged. So I'm not putting, I'm not the court and the judge and the jury, but this is alleged. But I'm just saying, I don't think it looks good for Marcellus Wiley at the moment. All right. Residential Dean Kathleen McDermott summoned another administrator whom plaintiff had never met. McDermott then required plaintiff to repeat the allegation in front of the administrator, a man and a total stranger to the plaintiff, after which both Columbia University administrators expressed fondness for the defendant, oh man, they expressed fondness, bro, nasty, for the defendant, Marcellus Wiley. These Columbia University administrators expressed doubt that the plaintiff had correctly interpreted the defendant's actions as grape, which is crazy for somebody to tell you if you felt you've been raped. I'm not saying it's all alleged, but you said you being raped, and people talking about what? They expressed doubt that the plaintiff had, who are they? Police? Who are they? Like investigators? How are you doing this, bro? Y'all probably weird in the building too. You know, some of these people be weird. The defendant's action as grape and suggested that the event was a misunderstanding. The plaintiff firmly explained that she had been raped and that the grape was not her fault. Astonishingly, the Columbia University administrators then informed the plaintiff that they had spoken to the defendant, Marcus Wiley, and shown him the plaintiff's written statement. What kind of thing is that? Why would you be showing him that and not showing some authorities this? What are you showing him this for? He's a student. How are you taking care of something by showing him exactly what's said? You want to keep those kind of things off the cuff so that, you know what I mean, when you get his side of a story, then you could try to do a comparative, right? That's kind of weird that they even upped his mind and put him on game. Plaintiff's written statement, even before they met with the plaintiff, the Columbia University administrators told the plaintiff that the defendant, Marcellus Wiley, did not disagree with the plaintiff's description of the events. Did not disagree? The Columbia University administrators told the plaintiff that the defendant was very sad about graping plaintiff because he really liked her, but the defendant nevertheless just disagrees that it's grape. That's weird. That whole little sentence right here, this whole little part is where he agrees. He don't disagree. So he's saying that they both did it, obviously, but you denying that it was a grape. But how do you say it right here? He felt very sad about graping the plaintiff because he really liked her. How do you say that? Is this his words? But you don't think it's grape? That's weird. Okay. McDermott then told the plaintiff that in McDermott's opinion, the defendant had not actually graped the plaintiff because the plaintiff was not from America and had therefore misinterpreted the defendant's conduct because people from different cultures interpret things differently. That's weird as hell. What are you talking about? Grape is grape anywhere you at. You got a book, you got a Bible, you got scriptures. What, you got Qurans? What are you talking about, bro? No matter where you're from. That's weird as hell, bro. People from different cultures interpret things differently. What? If you're forcing yourself on me, what are you talking about? Pause, not on me. But if you're forcing yourself on a person, that's weird. The person said they wasn't even naked around a person before and was a virgin. So how would you not know what's going on with your body, bro? If you're also a virgin. Okay, that's if you are, you know, because it's all alleged. But if we're going by what the story's saying, this don't even make sense for them to say that. They just caping and capping for him, son. This statement right here. It's crazy. Anyway, the other administrator did not contradict McDermott. In other words, the plaintiff grape did not count in Columbia, in the Columbia University administrator's eyes because of her ethnicity, country of origin, and immigration status. That's wild. The Columbia University administrators then told the plaintiff that they would look further into it and the defendant Marcellus Wiley would be disciplined. Remember, they said he was going to be suspended. Okay, McDermott explained that Columbia University would not expel the defendant, but that the defendant would be suspended and that the incident and the resulting disciplinary action would go on the defendant Columbia's university record. However, upon information and belief, the Columbia University administrators then instead arranged for the defendant to be placed on academic probation, the basis for which was listed on the defendant's record as poor grades. So he wasn't even on academic probation for the actual situation that happened. They decided it as poor grades, which many people are on academic probation for that same reason, rather than for actual assault. Now, the defendant Marcellus Wiley was required to complete the spring 1995 semester from home in Los Angeles. They said he had to do it remotely from home in Los Angeles, but was not officially suspended, nor was plaintiff's allegations reported to law enforcement by the Columbia University administrator. This is my part, because they showed him the documentation and all of these different things, got him up on game of what her story is or her side of the allegations. So you're basically bringing his mind up to speed, right? And didn't show the actual complaint to any law enforcement and any officials so that they could have done and conducted a proper investigation based on her own information and what she filed in her complaint, and then based on what he's going to say happened from his own words and not from knowing her words and being able to compare and be able to combat what she's saying. You know what I'm saying? So they actually made him privy to the filing, which is crazy. Over the following month, the plaintiff was advised by other students that the defendant Marcellus Wiley had actually assaulted several other female students prior to the plaintiff's actual assault, and that some of the defendant's victims had reported the actual assaults to Columbia University without any meaningful response from the Columbia University. Now, during the spring of 1995 semester, while the defendant Marcellus Wiley was in Los Angeles on academic probation, plaintiff and plaintiff's friend, who had encouraged the plaintiff to report the grade, began receiving harassing telephone calls in which the caller would breathe heavily and then hang up. After several of these phone calls, the plaintiff went to Columbia University investigators and Assistant Director of Security James Lynch. The plaintiff told Lynch about the calls and showed Lynch a copy of her written statement, whereupon Lynch, gobsmacked by Columbia University's callous handling of the situation, told the plaintiff that he would take care of it. Now, a few days later, Lynch summoned the plaintiff back to his office and told the plaintiff that he had spoken to the defendant, him as well. Wow. And the defendant, Marcus Wiley, would not be calling the plaintiff again. That when he returned to campus, the defendant would not look at her or speak to her, and that if the defendant Marcellus Wiley ever tried to communicate with the plaintiff in any way, the plaintiff should report it to Lynch right away. Now, the plaintiff never received another harassing phone call after Lynch spoke to the defendant. Well, finally, at least Lynch came and spoke up and did something on the lack thereof of what Columbia University was trying to do. At least he, you know what I mean, made her feel safe, you know what I'm saying? Regardless of the fact we got children, sometimes you just don't want to believe stuff, but you got sisters, you got moms, you got, you know what I mean, cousins, you got, you know what I mean, friends, you got children, daughters, nieces, you know what I mean? Come on, bro. You just want somebody to make a claim that, you know what I mean, one of those people to make a claim and it just goes just under the bridge, you know what I'm saying? So we want to take claims as serious, at least, you know what I'm saying? And you know what I mean, if he has his day in court, he has his day in court. But upon information and belief, just 1 month prior to the plaintiff's actual assault, a female Columbia University student told the deputy's athletic director, Jacqueline P. Blackett, that she had been actually assaulted by the defendant, Marcellus Wiley. You got mad people coming out, bro. He ain't no big millionaire yet. All of these people's coming out. It's craziness. Whereupon Blackett told the female student that complaining about the assault was likely to be a waste of time. Now, Blackett said that she would tell the defendant, Marcellus Wiley, that the female student had said, but only after Columbia University's upcoming football game, which is nasty work, against Princeton University, because Blackett did not want to interrupt the defendant's concentration before the big game. Now, Blackett warned the female student to consider her own reputation. They always do this to you, shame you for wanting to come out about your stuff. They come shame you down. That's why victims don't want to come out, because this is what happens. They're telling you this, consider your own reputation. See what I'm saying? Another reason for you not to speak your mind about something. Feel me? It's crazy. Before repeating the allegation to anyone else, after an aforementioned Princeton game, Blackett did tell the defendant, Marcellus Wiley, about the allegation, after which Blackett told the female student in some substance that the actual assault was the female student's fault. That's crazy. And that Blackette would not take part in derailing a good black man's NFL chances. Oh, I know how you mean, man. A lot of people do go through that, but you know what I mean? Crazy. It's a tight situation right there. The female student who reported the assault was also black. Or so they was both black. So what the hell are you talking about? You don't want to stop a black man, but then you're also trying to put down a black woman. So you could see if his mommy, if the person was white and he was black, but she was also black. That's why they meant to highlight that, because I was wondering what her race was or what she was. But as a result of the sexual assault on plaintiff by defendant Marcellus Wiley, the plaintiff suffered serious physical injuries as well as serious psychological injuries, financial injuries, and educational injuries, and career injuries. The plaintiff was traumatized. For the entirety of 1995 to 1996 academic year, the plaintiff was forced to attend classes on campus with the man who raped her. That's crazy. Defendant Marcellus Wiley, not even separate them. She can't take classes with this person, at least. You know what I'm saying? Because y'all ain't do nothing else. Least you could do is that, right? If a person's making a claim and you taking it as serious or somewhat serious, at least separate them, that they don't have to be interacting with each other. Even though when you're on school campuses and school grounds, even when you're in like high schools, you're going to see a person on school grounds a lot of times. I mean, maybe 8 out of 10, if not 9 out of 10, if not 10 out of 10. So the plaintiff returned to her home in Brockton, Massachusetts, and wrote to Kathleen McDermott to inquire about the procedure for taking a 1 or 2 month leave. McDermott, who had previously, the plaintiff had not been raped. Damn, bro, she ain't been raped. How you so sure that she haven't been raped as a woman as well? Why wouldn't you want to take a woman's claim serious? You know what I'm saying? Instead, that the plaintiff take 1 year mental health leave, 1 year away from school to seek treatment as a victim of sexual assault. So wait a minute, you don't believe it happened or something, but you want me to take 1 year off leave for treatment of a victim of an sexual assault? So that means either I've been through it or I haven't. And why aren't you taking it serious if that's the case, right? The following spring, while on mandatory leave, the plaintiff attempted unaliving herself. Damn. And was admitted to a locked hospital ward for 2 weeks before being released. Sad. Upon information, damn, this person went to this length, attempted unaliving, bro. And these things are documented, and that's crazy, bro. So you think this person's just doing that to themselves for nothing? Just for a payout and a money grab like you're making it seem, sir? I don't know, bro. It's kind of crazy. Upon information and belief, the defendant Marcellus Wiley never missed a single football game in 1994 season and remained eligible to play in the 1995 season when he returned to Columbia University. Now, the plaintiff became active in Columbia University's chapter of the Take Back the Night, an international nonprofit organization with the mission of ending sexual relationship and domestic violence in all forms. Through her volunteer work for Take Back the Night, the plaintiff often spoke to other victims of campus sexual assault. On several occasions, the plaintiff learned that other female students had reported being sexually assaulted by the defendant Marcellus Wiley to Columbia, both prior to and after his sexual assault of the said plaintiff. Now, Columbia University's callous, negligent, reckless, and deceptive responses to and handling of the plaintiffs and other students' allegations was an unconscionable re-victimization of plaintiff, which caused psychological injuries, financial, and academic damages. Now, the plaintiff graduated from Columbia University in 1999. Kudos to that still. The next year, the plaintiff accepted the position of the associate director. Wow. Of Columbia University's Center for Core Columbia Curriculum, sorry. And the office that oversees Columbia University undergraduate liberal arts program. Now, several years later, the defendant Marcellus Wiley was nominated for the Alexander Hamilton Medal, the highest honor that one can receive from the Columbia College Alumni Association, awarded to members of the community for both distinguished service to the college and exceptional accomplishment in any field of endeavor. Now, plaintiff challenged the plan for his award in the light of the defendant's history of sexual accreditation at Columbia upon information and belief Columbia University, concerned about adverse publicity, changed its plan and awarded a Hamilton Medal to a different alumnus. So look, boom, they changed their position. They was about to give it to him, but then she questioned that. So then they done switched it off and gave it to somebody else. See what I mean? That's weird. If y'all felt so strongly about him, why not still give it to him? Y'all done swept it under the rug. Y'all did all these different things. Y'all even went as far as to say that the person didn't know what grape was because they was from a foreign country or from a different background or different ethnicity or had different immigration statuses. So y'all was acting like y'all put yourselves in the position of God, put yourself in the position of law enforcement, put yourself in the position of special victims unit. Now, I mean, Marisha Hagate, like you said, CSI, I mean, like you Law and Order something, whatever the case may be, CSI. And okay, as and for the first cause of action of the sexual assault, as set forth herein, on or about November 18, 1994, defendant Marcellus Wiley intentionally caused the plaintiff to fear him, intended, attempted, and was about to cause harmful or offensive bodily contact, and caused the plaintiff to believe that the defendant was about to do so. Okay, you know what I also want to look up? I just want to make sure. 1994, let me just Google this one time. Hold up. What was Marcellus Wiley college football stats in 1994? All right, cool. Let me just Google that while I'm looking up this. All right, cool. The conduct was without justification for his actions. The conduct was willful, wanton, and reckless, such that punitive damages are warranted. All right. So yeah, because if we look up this and it looked like he was balling out and he talking about he wasn't no star and was he scouted on a high level, then he's just fluffing, sending wind up our sails, and he's basically peacocking, fluffing us too as well. You know what I mean? The viewer. And as and for the second cause of the action of the actual battery, defendant intentionally and without the consent of plaintiff engaged in harmful and offensive bodily contact with the plaintiff by actually assaulting her and attempting to commit further actual offenses against her. The defendant was without justification for his actions. The conduct of the defendant was willful, wanton, and reckless, such that punitive damages are warranted. And the neglect the negligent infliction of emotional distress. Now, the defendants, their agents, and or employees negligently, carelessly, and recklessly cause emotional distress to the plaintiff as a direct proximate result of the defendants, their agents, or employees' negligent infliction of emotional distress the plaintiff sustained in the past will sustain in the future, and suffering. Another one, same thing. Intentional infliction of emotional distress beyond civilized society. Okay. The acts set forth herein were extreme, outrageous, intolerable, and beyond the bounds of decency tolerated in this society. Now, the defendant's actions were intentionally designed to cause the plaintiff severe emotional distress, or were taken with reckless disregard of the significant and or substantial probability of causing the plaintiff severe emotional distress. And as a direct proximate, the results of the defendants, their agents, okay, you know, we read that before, same thing. Pain, sustained payouts and pain and suffering. Okay. At all times relevant to this action, the defendants had duties to provide their students, including plaintiff, with a reasonably safe environment to protect victims of sexual abuse from being re-victimized by their assailants, and to provide students, including plaintiff, with, at the minimum, the protection set forth in the Columbia University's own policies and the applicable ordinary standard of care. Imagine you send your kid to school, boom, they making complaints to the school about something that they feel happened to them. The school sweeps it basically under the rug, still allows the same student, after they said they're going to suspend the said student, they're going to penalize the student, all of these things never do. Then your child is still in the same classrooms as said student that has harmed your child. Not only that, People are saying that you don't know what you're talking about because you're from a whole nother country. Like you don't know what your body is, and somebody's violating your body. Don't matter. A young person, a young little kid can know that someone's doing that to them. Don't matter. Feel me? You're doing something wrong. So just the negligence of this whole situation is just pretty crazy. The defendants breached these duties by, this is Columbia University itself. The defendants breached these duties by failing to promptly remove a student with multiple allegations of sexual abuse against him from plaintiff specific dormitory, from student houses in general, and from general student population, as well as by conducting its investigation in a deceptive and insensitive manner in violation of Columbia's university's own policies and applicable ordinary standard of care. They even came with the letter, gave him the letter to read, right? Didn't call no law enforcement, didn't get no investigators to really look into the situation. Once you bring him privy or make him privy to the set information that the student is coming out and alleging against him, now he can do a counter, counter argument to what the person is saying, as well, So I just think the way they handled that, allegedly, but the way they handled that as far as Columbia University was very negligent and very reckless. So the defendant's negligent, reckless, wanton, and or recklessly indifferent acts and omissions directly and unnecessarily cause plaintiff additional pain and suffering stemming from the already tragic sexual assault by the defendant, Marcellus Wiley. Now, as a direct and proximate result of the defendant negligent, reckless, wanton, and or recklessly indifferent acts and omissions, plaintiffs suffer damages, including but not limited to emotional trauma, mental anguish and suffering, impairment of reputation, personal humiliation, embarrassment, substantial anxiety, and economic loss. As and for the sixth cause of action, which is the breach of contract, the actions described herein are caused in whole or in part by the negligence and carelessness of the defendants. The plaintiff entered into an arrangement with the Columbia University and as part of that agreement paid tuition and other compensations to Columbia University in exchange for certain benefits. As part of the agreement, the Columbia defendants promised to provide Columbia University students, including the plaintiff, with a reasonably safe environment. This is the contract. You're taking people payments to protect the victims of sexual abuse from being re-victimized by their assailants and to adhere to the canons set forth the truths in the Columbia University own student bill of rights and other policies. Now, the Columbia defendants breached their promises by failing to provide a reasonably safe environment, by failing to promptly remove a student with multiple allegations of sexual abuse against him from the plaintiff specific dormitory, crazy, still was in the same dorms, student housing, and general student population, and by conducting its own investigations, which was crazy, in a deceptive and insensitive manner in violation of Columbia University's policies and applicable ordinary standard of care. As a direct result of the Columbia defendants' breach of contract, the plaintiff did not receive the benefits of her bargain. Y'all taking people money, but y'all ain't living up to your end of the bargain. You're just sweeping people cases under the rug, people situations under the rug. That's pretty crazy. Sustaining monetary damages as well as consequential damages relating to the disruption of her education. Now, negligent hiring, retention, and supervision. Columbia defendant had a duty to supervise and prevent known risk of harm to its students by its employees, including plaintiff, and breached this duty. The Columbia defendants were negligent in hiring, retaining, and supervising its personnel who were careless, unskillful, negligent, reckless, and acted in willful and wanton manner in failing to properly train employees and staff and failing to take appropriate and timely disciplinary actions. At all relevant times, the Columbia defendants, agents, servants, and or employees failed to properly observe, supervise, inspect, and monitor the conduct, duties, and tasks being carried out by its employees where it's known and or foreseeable that students could be victims of sexual assaults. Now, the Columbia defendants, agents, servants, and or employees did nothing to investigate or prevent further malfeasance by the defendants, Marcellus Wiley, demonstrating their conscious and reckless disregard for the safety of students on its campus and ratifying defendant Marcellus Wiley's conduct. Now, as a result of such negligent hiring, supervising, and retention, plaintiff was caused to suffer serious personal injuries, emotional distress, conscious pain and suffering, mental anguish, and or physical manifestations thereof, and other losses, all of which have not as of yet been ascertained. Now, as a result, damages. As a result of the actions set forth herein, the plaintiff has been injured physically and emotionally, suffered trauma to her body systems, suffered mental and emotional damage, financial loss, injury to her career and education, all of which injuries will be permanent or have permanent effects, suffered financial loss, and which have required and will require in the future medical care. Now, the acts set forth herein were extreme, outrageous, intolerable, and beyond the bounds of decency tolerated in this society, for which the defendants are liable in punitive damages. By reason of all, the foregoing plaintiff was damaged in sum which exceeds the jurisdictional limits of all lower courts, which would otherwise have jurisdiction. By reasons of all, the foregoing plaintiff was caused to sustain serious injuries in that her reputation was damaged, her good name was damaged, and she has suffered shame, depression, embarrassment, mental strain, mental anguish, mental distress, extreme emotional distress, and humiliation. And as a result of said injuries, the plaintiff has been caused to incur and will continue to incur expenses for professional and or medical care. And the plaintiff was and will continue to be rendered unable to perform her normal activities and duties and has sustained a resultant loss therefrom. Now, the defendant's acts and omissions were negligent, grossly negligent, malicious, and intentional, wanton, and so reckless as to the amount to the conscious disregard of the plaintiff and justify the award of punitive damages. Wherefore, the plaintiff demands the judgment against the defendants where herein in a sum exceeding the jurisdictional limits of all lower courts, together with punitive damages and the attorney fees, costs, and disbursements of this action. This is the verification. Let me see. Jessica Woodrow, an attorney, duly admitted to practice before the courts of the state of New York, affirms that the following to be true under the penalties of perjury. I am an attorney for the plaintiff. I have read and annexed the complaint and know the contents thereof, and the same are true to my knowledge, except those matters therein which are stated to be alleged upon information and belief. And as to those matters, I believe them to be true as well. My belief as to those matters therein not stated upon knowledge is based upon facts, records, and other pertinent information contained in my files. This verification is made by me because the plaintiff is not presently in the country where our offices are maintained.